August 2025 immigration rulings. Courts push back, policies shift. The month of August marked a turning point in the U.S. immigration landscape as courts and policymakers delivered a series of rulings with far-reaching consequences. From protecting constitutional rights to challenging controversial executive actions, these developments are redefining how immigrant communities experience justice, security, and opportunity. Each decision underscores a delicate balance between enforcement, due process, and America's long-standing constitutional principles. If you are interested in this topic, please pay attention and watch the video through the end to get all the information. Please hit like and subscribe, and don't forget to push the notification bell for an upcoming video. The month of August brought a series of pivotal legal developments that are reshaping the immigration landscape in the United States. These rulings are not only protecting immigrant communities, but also ensuring that constitutional rights remain intact. Below is a breakdown of the most impactful court decisions and policy changes. Ninth Circuit blocks unlawful raids in California. The Ninth Circuit Court of Appeals reaffirmed an injunction against unlawful immigration raids across California. This ruling established that federal authorities cannot detain individuals based solely on their appearance, location, or workplace. In Los Angeles and other cities, the decision has led to a visible decline in raids and community protests, offering relief and restoring trust. By curbing federal overreach, the court underscored that civil liberties cannot be compromised in the name of enforcement. Birthright citizenship executive order halted. In another landmark decision, the Ninth Circuit issued a nationwide injunction blocking an executive order that sought to end birthright citizenship for children born to undocumented parents in the U.S. The courts have consistently rejected such efforts, affirming that the 14th Amendment guarantees citizenship by birth. This ruling was a decisive victory for immigrant families, reaffirming long-standing constitutional principles that have defined America for generations. DOJ's 3,000 arrests per day claim debunked. Rumors of mass detentions claiming the Department of Justice was targeting 3,000 arrests per day were dispelled by credible reporting from outlets like Politico. Courts have made it clear that mass, indiscriminate detentions cannot move forward. Ongoing litigation has prevented federal authorities from carrying out unlawful detention strategies, ensuring that due process remains a safeguard for thousands of individuals. Protection of parole status for vulnerable groups. Humanitarian parole programs for nationals from Cuba, Haiti, Venezuela, and Nicaragua face attempts to roll back protections. Courts, however, stepped in to preserve the status of over 500,000 individuals currently shielded under these measures. This ruling ensures that vulnerable migrants continue to receive humanitarian relief rather than being subject to hasty removal. It stands as a monumental win for human dignity and protection of the most at-risk populations. Bond granted in removal proceedings. One of the most promising shifts came when an immigration judge granted bond to a detained individual, countering the government's push for indefinite detention. The Board of Immigration Appeals upheld the decision, signaling a possible shift toward greater recognition of due process rights. This case provides hope for countless immigrants who face prolonged detention without the opportunity for release. Green card seekers and the Anti-Americanism test. A new USCIS directive introduced an Anti-Americanism test for green card applicants. Officers are now tasked with assessing whether applicants have promoted anti-American, terrorist, or anti-Semitic views. While the policy aims to protect national security, critics argue it gives immigration officers excessive discretion. The lack of a clear legal definition for anti-Americanism raises fears of arbitrary denials, echoing past eras of political suspicion, concerns over vagueness and subjectivity. Immigration lawyers warn that the vague standard could blur the line between legitimate threats and personal political expression. Critics note that anti-Americanism has no precedent in immigration law, making it susceptible to subjective interpretation. Comparisons have been drawn to McCarthyism, where suspicion and ideology replace clear legal standards, creating uncertainty for applicants and legal practitioners alike. Wider immigration changes under the Trump administration. The new directive aligns with broader policy shifts under the Trump administration. These include increased vetting of social media accounts, stricter scrutiny of naturalization applicants, and redefined standard for good moral character. Immigration experts suggest the administration's intent is to narrow eligibility and reduce approvals, a strategy described as shrinking the strike zone. Trump administration resurrects neighborhood checks for citizenship applicants last used in first Bush era. U.S. Citizenship and Immigration Services will interview neighbors and employers about applicants seeking naturalization. The Trump administration is restoring an immigration policy that was last used under former President George H.W. Bush's tenure to conduct neighborhood investigations related to immigrants applying for U.S. naturalization, according to a policy memo released Tuesday by U.S. Citizenship and Immigration Services. U.S. Citizenship and Immigration Services is resuming personal investigations of aliens applying for naturalization in accordance with Section 335A of the Immigration and Nationality Act. The memo, dated August 22nd, but released publicly Tuesday, states, "The 1965 Immigration and Nationality Act abolished immigration quotas and championed welcoming those who can contribute most to this country, to its growth, to its strength, to its spirit," according to President Lyndon B. Johnson's remarks at the time of him signing the act into law. The administration's revitalization of personal investigations, also called neighborhood checks, will include U.S. Citizenship and Immigration Services requesting information from immigrants seeking naturalization, such as testimonial letters from neighbors, employers, co-workers, and business associates who know the alien and can provide substantiated information about the alien, including any of the requirements for naturalization. U.S. Citizenship and Immigration Services is an office under the Department of Homeland Security's umbrella that oversees the nation's legal immigration processing. The memorandum stated that U.S. Citizenship and Immigration Services generally waives the requirements for neighborhood investigations under the 1965 law, and historically had relied instead on FBI background checks to determine an applicant's good moral character and eligibility for naturalization. The personal investigations will now include interviewing a naturalization applicant's neighbors and employment history stretching back at least 5 years before an individual applied for naturalization, according to the memo. The checks are to ensure scrutiny of an alien's residency, good moral character, attachment to the U.S. Constitution, and disposition to the good order and happiness of the United States. Such investigations were last conducted in 1991 during the first Bush's tenure. According to the memo, similar investigations were carried out on immigrants applying for naturalization as far back as 1802. The memo added, from 1802 to 1981, petitioners for naturalization were required to present 2 witnesses who could testify to their qualifications for citizenship, the memo stated. In 1981, Congress eliminated the requirement for witnesses, a change justified in part by the fact that a petitioner's character could be better determined by an investigation, including a neighborhood investigation, if necessary. However, by 1991, the former Immigration and Naturalization Service had essentially stopped conducting neighborhood investigations. U.S. Citizenship and Immigration Services celebrated the return of the personal investigations. Joseph Edlow, the director of U.S. Citizenship and Immigration Services, said in comments provided to Fox News Digital Wednesday that the office is working to ensure that only the most qualified applicants receive American citizenship. The Immigration and Nationality Act directs USCIS to conduct personal investigations, and incorporating neighborhood investigations will help enhance these statutorily required investigations to ensure that we are meeting congressional intent, he continued. Americans should be comforted knowing that USCIS is taking seriously its responsibility to ensure aliens are being properly vetted and are of good moral character, attached to the principles of the Constitution of the United States, and well disposed to the good order and happiness of the United States. The move is the latest of the Trump administration's crackdown on illegal immigration that spiraled under the Biden administration. Democrats increasingly have spoken out against the Trump administration's immigration policies, slamming its mass deportation efforts while ramping up visits to detention centers to draw attention to facilities, the Associated Press reported. Transparency matters. Oversight matters. Accountability matters. Colorado Democratic Representative Joe Negus said in August after visiting a Colorado detention center, "You certainly can expect to see the Democratic members of Colorado's House delegation continue to lean in on all fronts. As these rulings ripple across the nation, one thing is clear. Immigration policy in the United States is evolving through both courtroom battles and administrative actions. While some measures bring reassurance and relief, others raise questions about fairness, discretion, and the future of immigrant rights. The outcomes of these legal shifts will continue to shape not only the lives of millions of families, but also the very identity of America as a nation built on inclusion and constitutional values. That is all for today in this video. What are your thoughts on this? Please let us know in the comments section below. Thanks for watching the entire video. Hopefully, the information is useful to you. See you later in the next video. Till then, take care.
August 2025 immigration rulings called pushback, policies shift. August witnessed a wave of major legal and policy shifts reshaping U.S. immigration. The Ninth Circuit blocked unlawful raids in California, ruling that federal authorities cannot detain people based on appearance or location, reinforcing civil liberties. The same court halted an executive order seeking to end birthright citizenship, reforming the 14th Amendment. Reports of the DOJ conducting 3,000 daily arrests were debunked, with the court stressing due process protections, humanitarian parole for over 5 lakh nationals from Cuba, Haiti, Venezuela, and Nicaragua was preserved, ensuring relief for vulnerable groups. An immigration judge granted bond in a removal proceedings, signaling a stronger recognition of due process. Meanwhile, USCIS introduced a controversial anti-Americanism test for green card applicants, criticized for vagueness and potential abuse. Broader Trump-era policies include stricter debating narrow eligibility and revived neighborhood or chats for naturalization applicants, requiring testimony from neighbors and employers. Together, these developments highlight a growing tension between enforcement priorities, constitutional safeguards, and immigrant rights.